Maybe at Remos.
So, okay, thank you all for joining the session on legal tips with Alex Loveyko. And we won't be dancing in here if you came here because you didn't want to dance. That's the only other session, I guess, happening right now. So we'll be learning from Alex some wonderful tips for starting online businesses, which I think will probably be a good way to go right now since we're all at home in front of computers. Why not start a business? So I will pass it over to Alex.
Yes, thank you, Melissa. Thank you so much. So I'm not gonna be, giving you long previews or whatnot. What we're gonna talk about is, how to start your business online, meaning the website or mobile app or any type of, cloud-based service, pretty much. Since everybody nowadays needs an online presence, and in the conditions that we're in, I think the online presence is the only thing we got. So it only makes sense to make sure that you have set yours one properly. So what do we got here? So what are the things that all online businesses must have, right? You got to have a domain name, right? You got to have a URL. In cases of URLs, I've had a lot of clients who've been asking me in regards to the correlation between the domain names and the trademarks. And here I'll talk about it a little bit later. Just make sure that you do a check and see whether your name that you want to register the domain for is actually registrable as a trademark before you get a domain name and spend a lot of money doing that. Terms of use is one of the most important documents that your online business can have, due to the fact that it is the contract that actually establishes the relationship between yourself and the user of your website. So if you want to ensure that you're protected from liability, if you want to make sure that the users act in a particular way and don't use the content of your website in a particular way, and you want to make sure that those contracts are enforceable, right? So we'll cover that as well today in the session. Copyright protection. There are a couple of aspects to this. Number one is you want to obtain protection in regards to the elements of the website and the software, the program. And the second thing is you want to make sure that you register as a DMCA designated agent, and I'll cover what it is, to make sure that if your users can post any content and they post something that doesn't belong to them, you will not be liable for that. The next thing that we have is data privacy, that is governed by your websites or mobile apps privacy policy. Here you must make sure that you fall with all the domestic and foreign regulations in regards to privacy protection, and you are honest and responsible in regards to how you handle your users' information. The D&D agreement, that this can be called a programming agreement, a software development agreement, independent contractor agreement. Now there's a multitude of things here. This one talks about the design and development agreement. It's a question of you having a proper agreement as between yourself and the person who is actually developing the outlook of the website or the mobile app for you, to make sure that you actually own all the intellectual property in the website. And the additional miscellaneous documents that some businesses need, some don't. And user license agreements, that's only for mobile apps. If you want to protect some of the contents of your website that cannot be protected by intellectual property, you use trade secret policies and non-disclosure agreements. And the terms of sale and terms of subscription are the documents that you will need if you're providing any type of paid services to your customers, to make sure that all of the layers of your relationship with your user, as the user of the website, as the person from whom you're collecting data, and as the person that you're providing paid services for, all of them are covered. So let's move forward. So this is step number one. I did not cover it in the first slide, but this is probably the most important thing that you need to remember. You got to separate your business and yourself. Your company has its own tax number. It has its own bank account, and you want to make sure that you keep it that way. Whenever you are, setting up any type of company generally, and in this instance, an online business, you want to make sure that all the protections, in addition to all of the protections from liability that your terms and conditions, your privacy policies, all of your disclaimers are going to provide you with, you have a separate layer of protections, and that layer of protection is going to come in the form of having a company be responsible for everything. All of your trademarks, register them to the company. The domain name, purchase it in the company's name. Make sure that everything goes through the company and that you do not commingle funds, as they say. If you select a legal, you got to select a legal entity that fits your purpose, right? Generally, there are a couple of main considerations. It's a question of whether you want to raise funds down the road, whether you want to raise institutional funds, involve venture capitalists or angel investors, or if you want to bootstrap and have your own project, don't worry about corporate formalities. Well, in this instance, LLC will do the trick. If you want to raise funds, C Corp is the way to go. Why is that? Well, I think you might be familiar with that already, but let me reiterate either way. C Corp is something that investors are familiar with. It's coming with an LLC to an investor is akin to coming with a Russian currency into an American bar. Is this a valid currency? Yeah, it is. Can the bartender run around and get fund, exchange the funds and get all the money from a bank that exchanges Russian currency into USD? Yeah, for sure he can. But you do not want to present the person from whom you want to obtain a service, in this case money, with necessity to go through complex procedures of changing the structure of your organization and things like that. That's where you want to ensure familiarity and go with the C Corp if you want to raise funds. Separate bank accounts means just that. If you are starting a project, you are starting a new entity, sometimes, of course, right, until the entity starts bringing in profits, you need to compensate the entity's expenses out of your own accounts. Sure. But make sure to save all of the receipts. Make sure to have a bookkeeper that is going to be following those procedures and compensating you later down the road from the account of the company. Make sure that everything is happening as if it would be in your standard business transaction. Because if down the road something happens and somebody wants to get to your personal assets, because this is what this whole thing is about, right? Establishing a company and limiting your personal assets from liability. If you do that, then you're going to be safe. Your home, your property, your car, all of those things are going to be safe. If you don't do that, then the creditors are going to be able to do something called piercing the veil and go after your personal assets. Using your company's money for personal purposes or personal money for company purposes, that is one of the best ways to allow them to pierce that veil. You have a co-founder, assign your roles. Clarify your roles, have an agreement, even if it's on a piece of napkin. Just make sure in the email exchange, make sure that you have clear understanding of what it is the responsibility of each of the parties. If you don't do that, you're going to sit in front of me in one of the office hour sessions and telling me that the CTO that you hired 5 years ago is not pulling his weight in gold, and now you want to break up with him. But you don't have a contract that would allow you to do that, or you don't have a properly drafted contract that would allow you to do that. So make sure that you structure everything out properly. And this is the motto of this slide, right? Starting right is cheaper than not. If you had a chance to take a look at Y Combinator and the videos that they are putting out there for their startup accelerator clients and the customers, that is one of the lessons that they're teaching there, and they are given an example of how improper structure of the startup at the beginning stages of a startup led to more than $500,000 in costs down the road in order to just reorganize everything and make sure that only intellectual property is assigned and things of that nature. So better make sure that you have everything right in the first try. So the names, right? We're talking about URLs, domain names. I've had several prospective and current clients ask me in regards to whether domain name gives you any type of trademark rights. Unfortunately, it doesn't. There are certain rules in regards to trademarks that do not apply to domain names. Whenever we are registering a trademark, there are two analyses that need to be performed at the very least. Number one is the mark already taken? Does somebody else use it in commerce for a similar set of goods or services? If not, then you need to perform a second analysis. That would be, is your name generic or descriptive? Meaning that back in the 80s, if Apple wanted to register its trademark for apples, it would not be able to do that. And similarly, if it wanted to register the mark personal computers for its personal computers, it would not be able to do that. So that mark would be generic. Descriptive mark is something where the service or good can be identified without much mental effort by just looking at the mark in a vacuum. So the further you are from your service or your goods in your brand name, the better it is for your chances of actually pulling the registration off. And why is that important in the domain name context? It's very simple: money. So whenever we want to register a catchy domain name, oftentimes those catchiest ones cost a lot of money. So you do not want to spend several $1,000s to only then realize that you cannot obtain exclusive federal protection of a trademark legislation in regards to your name. So you want to make sure that you make this research at the very least preliminarily. You can perform the research in regards to whether somebody took your mark already or not. You're more than everybody's capable of going to Google and finding things out for themselves, as well as going to the trademark electronic search system. All of that is all open to the public. However, the analysis in regards to descriptiveness and genericness in that regard, just either use read up some articles online, check what marks qualified for being generic or descriptive back in the day, and try to analogize with what your mark sounds like and looks like, or in an alternative, get an attorney. So the contract with the registrar. Well, I put this point here just because I had a couple of cases connected with this, but it's not something that is omnipresent or prevalent. I would say it's just a question of whenever you're registering your domain name with a particular registrar, Namecheap, GoDaddy, whatever it is, you want to make sure that you actually take a look at all the contract terms that they're providing you with, because they might include provisions that would allow them to completely terminate and erase your domain if you are not following some of the rules in regards to email correspondence, in regards to spam, in regards to the content that you have on your website. Generally the rule of thumb is pretty simple: if you are not doing anything illegal or harassing of any other customers, you should be fine. However, in some instances you want to make sure that you're not blurring the lines, and by taking a look at those contracts, you can select the one that best fits your purpose and your domain. So trademarks, once again, right, is best protection against domain theft, and same with social media accounts theft as well. If you have a strong trademark that is already registered, you will be able to claim social media accounts that are taken and not being used, or domain names that are taken and not being used, or people are cyber squatting on them, hoping that you're going to write to them and give them a check for a significant amount of money. If you have a trademark, you will be able to either file a complaint with the uniform dispute resolution providers, or with the social media network where the account is based. If you have a trademark, you have a strong case. If you don't, in most instances, the fact that you want to open a business and here's this social media account that is not being used, or a domain name that is not being used, that is not going to be a good argument for the social media network or platform to give you that domain name. Having a trademark infringement claim on their hands will make them a little bit more collaborative. So yeah, and uniformity is key, right? Uniformity is key. You want to make sure that all your online presence is uniform in its expression. You don't want to have your domain name be with an underscore, your Instagram account with a hyphen, and your I don't know, business cards having a dot there or whatnot. You want to make sure that you have the same thing for throughout all the different channels of communication. Save your money by being proactive, once again, right? So unique terms of use. The terms of use are the contract, as previously mentioned, between yourself and your users. So you want to make sure that you have terms of use that are actually governing the relationship with the user and the functionality of your website. I'm going to give you a couple of options in regards to how you can address this matter. So what I don't like is the template websites. Not template websites, meaning the websites that allow you to build websites off templates, like Wix. No, what I mean is I hate websites that provide people with template terms of use, template privacy policies, and things of that nature. Whenever somebody comes to me with a document like that, most of the time, not always, but in the majority of instances, it leads to me completely rewriting everything from scratch. Because those websites, they are either not exactly were built by lawyers, or they are just an amalgamation of different clauses from different websites that they have copied, that provide you with some type of security or protection, but you can end up having terms of use that completely do not reflect all the functionality of your website. So you can use them, but just do so very carefully and make sure that you actually, what here is, one of the, advices that I think is a little bit more, useful. You can follow your competitors. You can take a look at the people who are doing the things that you want to do and that are established enough to actually have an attorney draft those, terms and conditions, privacy policies for you, and take a look at what they have. Do not copy them blindly, because once again, if your product was exactly what they're providing, what is the purpose of you providing your product? So there must be some difference there, and those differences must be reflected in your terms of use, because this is an actual contract that must be enforced in order for you to have the value and all the protection that it provides you. Don't be greedy. What was that about? That was about the case of the app FaceApp. Might have heard about it. It's the app that makes you look older, or changes your gender on the picture, or makes you look younger. It has a lot of interesting filters, right? That app became popular in last year, middle of last year, if I'm not mistaken. And what happened with it is they had a pretty extensive terms of use provision that granted the app the license to use all of your content on your phone in perpetuity, throughout the universe, etc., etc. That led to an investigation due to the fact that the app was pretty popular, led by a New York senator, if I'm not mistaken. And by investigation, I mean he just opened and read it, of the terms of use in question, and him pointing fingers and screaming that it is the KGB that is trying to steal the soul of your baby. Why the KGB? Because the app originally was founded by my fellow Russian citizens. So the app that has gained popularity and was, on the tops of all of the charts for a couple of weeks, just suddenly became ostracized, because nobody wanted to, have the black cloud of PR hanging over them, pretty much. Nobody wanted to check whether the app in question is actually, stealing your data and, providing KGB with available information about the types of food that you ate in the last week. And everybody just pretty much deleted it, and I have not heard anybody use that app ever since. And all of that is just for the sole reason that they did not have an attorney draft, or maybe they had, but wasn't a good one. The terms of use in question were just too extensive and gave too much rights to the app in regards to the user's content. You want to avoid that for those PR purposes, so to say. Generally, besides that, terms of use, were used to deflect lawsuits of users against Uber. Somebody claimed that Uber drivers are in violation of a state statute that prohibits the use of phones when you're driving, and there was actually such a state statute. Somebody was claiming that Snapchat was inhibiting law-breaking behavior by its consumers by showing the exact speed that the drivers were going with, when they were using the app. Somebody was claiming trespass against Pokemon Go because its users were going around somebody's properties and catching Pokemons where they shouldn't have been. And oh yeah, one of my favorite ones. That was a customer of Google Maps, so one of us, who tried to sue Google Maps and Google generally for the fact that Google Maps drew a route for her that led right through the highway. So lady took a look at the, at the phone that said, go through the highway, followed it through that highway, got hit by a car. Surprise, surprise, 6 lanes going both ways. Google Maps is to blame. Everybody is always looking for the, deep pockets in that regard, and everybody's trying to sue, whoever has the money to, to provide that compensation. So the terms of use can actually, be a good, protective measure against, all of those lawsuits. So, policy of full disclosure. What we're talking about here, this is in regards to all of the privacy policies that you have, to see all over the web, right? Nowadays, there are several main pieces of legislation in regards to privacy policies. One of them is in the EU, the GDPR. And there are, there's a California one, there's a Maine one, there's a Nevada one. There are a couple of them here in the United States as well, and the Children Online Protection Privacy Protection Act as well. So there are several main pieces of legislation, and you want to make sure that your app is, or your website is under the jurisdiction, and you want to know what jurisdictions it is under, because if you are falling under the EU jurisdiction, if you're collecting data from European residents or monitoring their behavior or advertising to them, you will be liable for EU damages. And in that regard, that can be a very substantial sum of money. If I'm not mistaken, the largest fines imposed today, I think it was British Airlines, and they had 158 million pounds imposed on them for privacy violations. And Marriott hotels had a similar instance as well, because the GDPR allows to claim 4% of the annual revenue from the infringer in that regard. So you don't want to end up in that situation. Don't collect information from children. You can collect information from children, but if you do, and if your app is targeted at children, you want to make sure that you provide certain disclosures and require parental consent from if a child is using your app. In this instance, the case that comes to mind was TikTok. They had to pay over $5.7 million for collecting information from its users. So just want to make sure that you're careful there. So guys, feel free to ask any questions if you have them in the chat. Melissa is thankfully monitoring this situation and alerting me as to whether there are any or not. So if you have any questions in regards to the presentation or anything relating thereto, feel free to send them to the chat. So in addition, besides, don't collect information from children, you got to make sure that you inform users how you collect their information. What do you use it for? Do you sell it to somebody else? How, not how much do you sell it for, but rather, how long do you do that for? How long do you retain the information? The main policy in regards to privacy policies, my tautology is not intended, is to be honest. Be honest, be responsive to your users, requests to delete their private information, erase your private information, and just, treat your users in the way that you would like to be treated if you were one of, the users of whatever app. If you don't want your information to be sold to third-party advertisers, and you do not want to, receive targeted advertising as a result of you visiting a particular website, you have a right to, mainly California residents have that right. But Nevada ones as well, and Maine ones as well. There are several sets of regulations that govern those types of requests. So you want to make sure that you comply with them. You're responsible and responsive. So what do we got next? As previously mentioned, all of those terms, all of those privacy policies, they are the contracts that you have with your users, and they establish different sets of relationships between yourself and your users. So generally, there are two types of approaches to providing your users with notice in regards to your terms and conditions and privacy policies and all of that good stuff. One is browser wrap, is when you just put something on a website and place a link saying that, check here, this is where our terms are. This is mostly for the websites that do not require any sign up procedures or account registration procedures, don't provide any paid services, and click wrap. Click wrap generally has been found by courts to be enforceable. Browse wrap has not always been found to be enforceable by courts. So the main key here, the main takeaway is, did you do everything possible to ensure that your users had a chance to take a look at your terms and conditions? Because as is with any contract, you need to establish that there was mutual assent of the parties. And if your agreement, if your terms of use privacy policies are hidden below the fold, so to say, so meaning that somebody has to scroll down the website to actually get access to them, if that is the case, that might lead the courts to think that you were not as proactive as needed in ensuring that they are notified in all the different types of relationships that you are trying to establish with that. Now, the way to go about it with browse wraps is to place it in the most conspicuous place on your website, either the top of the website or my favorite, the navigation panel. If your website has a navigation panel that is always present on the web, always there, put it there. Then not bright red necessarily, depending on the design of your website, but generally you can make sure that it is as inconspicuous as possible. Make sure that it is as visible as possible. Make sure that your users' attention is drawn to your terms and conditions. And now, when we're talking about click wrap, here are several different layers of potential enforceability. If the worst case scenario is whenever you make sure that your users click your terms and conditions or agree to them by saying, or take me to the content, or give me my free ebook or whatever, right? When the actual button that they're pressing is not what they're agreeing to. So a little bit better situation is going to come when you are actually allowing your users to I agree, to click I agree, I accept, I have read, I am knowledgeable of your terms and conditions, your privacy policies. Do not pre-select the box. Make sure that they have to click it. Make sure that they have to tick it. And if you can save that information, you can do screen recording just once when you're launching your website to ensure that you have this video file that shows how your user accesses your service and what steps they have to go through in order to access your service. If you have that, you already made it significantly easier on your future self in trying to establish whether you require proper consent of your users or not. Because this video, this screen recording, allowing the court in the future to see the actual general user process that your users go through, will allow to establish that you are actually trying your best to make sure that they have actually read it and actually scroll through it. And now to the potential thought that maybe you don't want them to read it, right? Maybe you think that somebody might read them and not sign up for a service. When have you ever done that? When has somebody ever actually read the terms and conditions or decided not to sign up for something because of that? That is very rare. And good for people like that, because they make sure that they are knowledgeable in regards to what they're entering into. However, there was an instance where a large software provider placed a link in its terms and conditions saying that whoever is going to email us at this address is going to receive, the first person to email us is going to receive $10,000. They sent over 100,000 copies of the software, I want to say, in the first 3 months. And not a single person in the first 3 months called them or emailed them. The guy who did it after 2-3 months of the program being launched, leading us to believe that out of 100,000 people, there might be one who actually go through every little thing that you have in your privacy policy in terms of conditions. Now, what do we have next? Copyright. Yes, and we have copyright protection from your users. So this goes to the situation where you have a website that allows your users to post content. The website that has a forum, a messaging board, a chatting service, a video exchange service, an image exchange service, something that allows users to contribute. Because whenever users contribute, there's a chance that they might send somebody to post somebody that does not belong to them, leading to that person to whom it actually belongs to sue not the user itself, because users are mostly anonymized and you never know who the user is, to sue somebody with big pockets, as we previously discussed, and that would be you as the owner of the website. However, the legislators knew that in the 90s, when there was a dot-com boom and everybody was on the upswing in regards to the e-commerce businesses, everybody knew that this is how things are going to work out, and that internet service providers are going to be found liable. If they were to be found liable for all of the users' content, there would be no internet, because they would have to spend so much resources on trying to monitor their users' behavior that they would be just out of business. That led to them creating DMCA, Digital Millennium Copyright Act. This is the legislation that provides for a certain set of rules and procedures that you, as an internet service provider, can follow, therefore protecting yourself from secondary copyright liability. So nobody can sue you for users posting stuff that doesn't belong to them on your website. If you provide in your copyright policy or in your terms of use, it can be a separate document, can be the same document, information in regards to who to contact if they find some type of infringing content on your website. An additional step that is needed, and that is a requirement, is to register as a designated DMCA agent. That is very simple. You go to the copyright.gov website, you select, register as a DMCA agent, you pay $6, and you just provide them with information in regards to your contact information and the websites that you are trying to cover there. That will allow you to maintain protection from your users' infringing actions, and will allow you to, come out dry out of the water, so to say, in any type of copyright litigation and IP-related litigation, because the moment that somebody's claims gets into court, and you show that you have followed with all the takedown procedures, sent all the allowed everybody to send the notices and the counter notices, and followed all the steps, the lawsuit is going to be thrown out of court, because it's just going to be protected in that regard. So where are we going next? So all of the other documents that we discussed previously, those would be the terms of sale, the terms of subscription, the documents that you need to ensure that you have if you have a relationship with your users, the users of your website, that is compensatory in nature. If they are paying you for something, you want to make sure that you have a separate set of documents. Sometimes you can see terms of sale, terms of subscription being part of the terms of use. And that is completely fine, as long as you make sure that you provide specific language that subjects only your registered users or your subscribed users, your paid customers, to those terms. In that regard, you want to make sure that you have them separated for the purposes of, there's one relationship with your website's users, there's one relationship with your paid customers, and the terms of sale and terms of subscription are going to have all of those provisions in regards to refunds, cancellations, force majeure, and the limitations of liability, indemnifications, all of those things that every contract for the provision of services or for the purchase of goods must have in order to be not only viable from the legal perspective, but generally to protect you, to its best ability. Trade secrets. We previously talked about the website elements and the program and the object code, and source code, all the things that can be theoretically protected by copyright, right? Your logo can be protected by trademarks, your brand name can be protected by trademarks. The outlook of your website theoretically can be used as can be registered as an audio-visual work of art, and the outlines and the design elements of your website, if they're original enough, can be registered as a collective work altogether. But there are some things that you just cannot register with copyright. There are some things, some content that you're providing on your websites and your apps that is not registerable. Therefore, you need to make sure that you have a contract provision, a non-disclosure agreement of things of that nature that would allow, well, in regards to your users, you want to make sure that your terms of use contain some clauses that prevent them from copying your content or linking to your website in a situation that is not flattering to you. What if somebody posts a link to your website on a dark web website about human trafficking. You don't want that. But that is generally not illegal. You can't prevent somebody from linking to your website. But what you can do is ensure that in your terms and conditions you have a rule that that prohibits your users from doing so. And the trade secrets application here is going to be in regards to your employees. You want to make sure that some of the processes or the methods by which you are, algorithms by which you are, your project is as unique as it is, that they are protected not only by property laws, intellectual property laws, but also by contract between your company and your employees in regards to that confidentiality, to make sure that none of your employees go out and start a business or an online brand similar to what you are doing by using the information that you have provided them throughout the business. End user license agreements mostly apply to, not mostly, only apply to mobile apps. This is pretty much terms of use for mobile apps, and you can have both terms of use and end user license agreements. But if you have a mobile app, you need to have an EULA, because Apple and Google require that both Play Markets, the Play Market and the App Store, they require that you have certain provisions in your end user license agreements that indemnify them from liability. Just they want to be protected as well. And the website elements, we just discussed in regards to potential registrability of some of the elements of the website. A couple of other points to touch upon. Make sure that your website is ADA compliant, Americans with Disabilities Act. Make sure that people with disabilities can access your website, as well as the mobile app. The latest web content regulations in regards to their accessibility, they included some provisions in regards to mobile apps as well. Like, for instance, you want to make sure that the content of your website can be turned around. You want to make sure that it's available both horizontally and vertically, to make sure that people who have problems with movement and are looking at your website through their mobile phones in a wheelchair, for instance, they can actually access it in the way that it is presented in front of them without having to change things over, which is going to be significant hassle for them. So in addition, also, you want to make sure that your terms and conditions, any documents that you have on a website, that you allow your users to print them, because there is a particular regulation that governs any type of electronic contracts, and anytime that you enter into a contract with somebody electronically, you want to make sure that they have a right to copy that as well and print it out in order to be able to bring it down the road, somewhere in court of law. Otherwise, you would be able to change all of those documents, at the snap of fingers, and then say that, oh, they don't have any evidence that those were the particular conditions of our arrangement, and here's are the terms that we have now. How would you say that they were not this otherwise? You can use a Wayback Machine actually for those purposes, but generally the law is the law. You got to make sure that they can print everything out. So that will be the end of our presentation, and I think I have my contact information right here. Yes. Feel free to send me any emails in regards to whether your follow-ups or anything relating to the subject of the presentation, or anything relating to to my general fields of practice. I'd be more than happy to talk with you in regards to those things. And if anything, sign up for office hours with me here at Venture Cafe. Venture Cafe is providing me with an amazing opportunity to be able to help the community out and guide them in one-on-one setting, which is what I'm going to be doing in 15 minutes. So yeah, thank you guys, appreciate it.
Thank you, Alex. There is one question I just wanted to pose. This is from Eric. He asks, how can you enforce your terms of use contract when it is difficult to trace the user? Maybe they have plagiarized your content.
So the dynamic is this. Generally, what are we talking about? The enforcement, right? You want to make sure that with all the types of users that you have, there's software for that to ensure that all the users have clicked the buttons, right, and accented to all of your terms and conditions. Whenever somebody, if your terms of use are just something that, oh, the user accessed this website or they didn't access it, that is a little bit difficult, more difficult to prove. Generally, the claim for plagiarization is not something that can stand in copyright law. You need to show that there was actual copying of expression, and that what was copied was significantly similar. However, generally with internet, right? Back in the day, in order to show that somebody copied your book, you needed to show that they actually bought your book. Nowadays, this aspect of element of proof that you need to show access has significantly decreased, because everybody has access to everything. This is how Katy Perry lost her, well, then it was reversed, the damages were all reversed. However, she originally lost a lawsuit brought by a Christian gospel hip hop band that was suing her for the use of some of their sampling in Dark Horse. So they said that, look, our song won a Christian gospel Emmy back in 2000, God knows when. So it was significantly popular. It was on the internet. It was available. Therefore, your writers must have heard it, and therefore you must have copied it. The jury gave them the word. The court later reversed it, but access is not such a big, it's less about access. It's more about how much of the content did they actually copy, and can you, by looking at the two things, can you actually say that this was taken from this? In regards to potential, tracing IP addresses, there's software for that, but this is a little bit too expensive from the business standpoint. I would say, what is the purpose for you to trace the IP addresses of every single person that access your website? If you have the location data, that can because all of the websites and all of the mobile apps, most of them, they track your location data. If you have that, you can use that theoretically to build your case. What I would recommend if you're trying to identify this particular user is using a private investigator. They are as good as as it gets in finding people. So we work with a couple in that regard whenever we try to find somebody who's trying to avoid the law. What do we got? If somebody were to write a book summary of a book without copying any of the text, would that be okay? Look, here the thing is the following. Them providing summary of the book is pretty much protected by the First Amendment, because they're providing commentary to, or some overview, right? Their use is transformative in that regard. What copyright protects is the particular expression. So if I draw something on a piece of paper, and then you make a podcast about me drawing that, what you create might be based on what I drew, but you will still be able to claim First Amendment protection. You will still be able to, claim commentary protection of the First Amendment, and you'll be able to claim that either way, even if, say, First Amendment doesn't protect and what you did wasn't considered to be speech, that would be significantly transformative. That is one of the factors that courts, look at when determining fair use. Is the second work transformative? Meaning, if you take somebody's photo and then you make it into a graffiti by changing the stylistic, by changing, the outlook, by changing everything, you have made a new work. So the transformative character of your work allows you to not, require permission in some instances. If we're talking about a photo of somebody, that would also concern personality rights as well as the copyright rights. But generally, book summary is that is allowed.
Ooh, any more questions? Yeah, I agree, Eric. Very good presentation, very thorough.
Oh, thank you so much. Thank you so much.
Good info. So Alex is actually here and does office hours at virtual venture cafe a lot of weeks. So I think he has some open slots today, as well as looks like next week you'll be here again, Alex.
Always here.
Nice.
I like
nice.
this.
So there is an opportunity for you to get more of your specific questions answered. Thank you all for joining the session, and there's more stuff going on. The night's not over. I'm going to post real quick a link to check out the other things going on, especially our virtual cafe space is a whole new fun engagement exercise we're doing that I've heard is really good. So I'll post that link. It's really innovative, so check it out if you haven't been there yet. You kind of get to pop around to different tables and do some virtual networking. And let's see, if you haven't joined our community Slack, that's another great way for us to kind of keep the community connections going throughout the week. And I will just post that link in 1 second here. And we hope to see you guys again in another room.
Mm-hmm. Yeah, everybody go out and enjoy what, you know, VC has to offer. I'm sure there's a ton of interesting topics, conversations, and webinars going on as we speak. So make sure to check them out.